Court is calling 2020 CR 6566, and counsel, you on this side. State of Texas versus Jose Rizzo Sanchez. Can I have parties announced?
Rick Payne for the state of Texas.
Adelaide Silver for defense.
And are you Mr. Jose Rizzo Sanchez?
I am, Your
Did you review the motion to enter adjudication of guilt and revoke community supervision with your attorney? Did you understand it?
Yes.
Are you the same Jose Rizzo Sanchez who was placed on deferred adjudication in 2020 CR 6566 for the offense of assault, family choking, strangulation on August 23rd, 2021 for a period of 2 years? Is that you?
Yes.
State?
Yes, Your Honor. We're here this morning on state's motion to enter adjudication of guilt and revoke community supervision. Violation condition number 2. On or about the 7th day of June, 2024, in Bexar County, Texas, the defendant, Jose Rizzo Sanchez, did then and there illegally use a controlled substance, namely methamphetamines, in violation condition number 2.
You said on the 7th of June?
Yes, Your Honor.
I don't have a motion to revoke with the 7th of June on it.
This is the first one at the top I wrote.
All right. I don't know why I keep getting the incorrect motions to enter adjudication of guilt. Okay. To that, how do you plea?
True. We'll waive the remaining violations, Your Honor.
No objection from defense, Your Honor.
All right. Did you understand by pleading true to violation of condition number 2, the court could find it true, grant the motion, find you guilty, and sentence you up to 10 years in the prison and up to a $10,000 fine? Did you understand?
Yes, Your Honor.
Knowing that, do you still wish to plead true to violation of condition number 2?
Yes, Your Honor.
Court will find violation of condition number 2 true. Is there opposed agreement?
There is not, Your Honor. We're looking to go open as far as our recommendations.
All right. State, what are you requesting?
We're requesting adjudicate the defendant and sentence him to 3 years TDC.
All right.
We're recommending to follow probation's recommendations.
And what is that
That
recommendation?
is SAT.
All right. Would you like to tell me anything, sir?
Hmm.
All right. I don't think you're a good candidate for probation. This is not your first MTR. You've had a previous MTR for the same offense. Do you understand?
Yes, Your Honor.
All right. The court is finding condition number 2 true. The court will find you guilty. The court will grant the motion.
May we talk about time, Your Honor?
Yes.
Your Honor, then in the alternative, we would like to ask the 2 years TDC. No new offenses have been picked up. He has completed status twice, aftercare once, outpatient once, and he currently has 231 days in Bexar County Jail, as well as the 2 completed status inpatient programs. Only 1 aftercare was completed.
Okay. All right. So it appears, though, that nothing is working with you because you're continuing to repeat the same violations.
Thank you, Your Honor.
All right. This is what the court is going to do. The court will find you guilty, grant the motion. There's an affirmative finding of family violence. There's to be no contact with Vanessa Sanchez. State, has there been any new offenses or violation of the no contact order?
Not to the state's knowledge, Your Honor.
Probation, has there been any violations of the no contact order?
Judge, on the motion to revoke, there is a violation of condition number 27. In that on the 12th day of July of 2024, there was contact or attempt to contact Vanessa Sanchez.
Your Honor, I
Or
would
a
like to.
family member by telephone, mail, or person. I know they waived that violation, but that is based on rules.
Your Honor, so that was he admitted to probation that the CW was going around to his home. There are incident reports where him and his family, since it is a family home, did call because she is returning to the home because her children do live there.
All right, this is what the court will do. The court is going to, as previously stated, find you guilty, revoke. There's an affirmative finding of family violence. There's to be no contact with Vanessa Sanchez, no residing with children, 4 years in the prison. Did you review the document entitled, and I'm sorry, credit for any time served? And credit for any time served in inpatient treatment successfully completed,
The inpatient part, Your Honor, or the aftercare part?
inpatient.
Okay.
Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes.
Because this is a plea bargain, I'm sorry, because this is not a plea bargain agreement, you do have a limited right to appeal. And that right to appeal is as it relates to the allegations in the motion, not the fact that you're on deferred adjudication. Because this is a felony conviction in an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question about any of that, you'll need to speak to an attorney. Do you understand?
Yes, sir.
All right, and then the court will recommend the therapeutic community. The therapeutic community doesn't increase the time that you're in custody. However, it's there to help rehabilitate you. Do you understand?
Yes, Your Honor.
All right, good luck to you.
And he still has to ask for that when he's there as well?
Yes.
Correct? Okay.
Yes,
Yes,
thank you.
thank you,
Good
Your-
seeing you.
Nice seeing you as well, Your Honor.
Going.
Judge, I'm blessed.
Yes. All right, if you'll make sure Christine Brown gets copies of that, please. All right, so today an offer was due. Were you all able to attend an offer?
Judge, we're in negotiations. I've conferred with Mr. Garahan. And Your Honor, I just would like a 1 month reset. We want to talk to our client. Like there's a chance we could work it out, and I'd like to just talk to him
Okay.
and go through that with my co-counsel.
All right, Ms. Ferguson. On this case, if you can give me a 30-day reset for a plea deadline date, please.
So Judge, even like if you had anything in early September, I don't know if you do.
Sure, I understand what's going on, counsel.
Thank
Okay,
you.
Ms. Ferguson, if you'll put this early September.
Yes.
That's perfect.
All right, and everything's gonna go well for you. I know it.
Judge, I'm doing my best to do my duty.
Oh, no, you know what?
And thank you for sharing.
Sure. You know, the key, they tell me you remove the stress, right? So it's gonna be fine.
Thank you. I really appreciate that. I always like the flowers too. It's good.
Hey, you know what? We gotta bring some beauty somewhere.
Amen to that.
All right. Thank you for addressing appropriately for court. Just have a seat. Once you sign the reset form, you're excused.
Thank you.
No, it's a plea deadline date. That's why when people are sitting and they're staring at me, I'm like, why are they staring at me? I'm like, I don't have anything. All right, court is calling 2024 CR 007949 State versus Roxanne Hutchinson. Can I have parties announce?
Megan Galloway to the state. For the defense.
And are you Roxanne Hutchinson?
Yes, ma'am.
All right, did you review the motion to revoke community supervision and state's motion to supplement pending motion to revoke with your attorney?
Yes,
Did you understand it?
Yes, ma'am, I did.
Are you the same Roxanne Hutchinson who was placed on community supervision in 2024 CR 007949 for the offense of unlawfully carrying a weapon with a felony conviction for 7 years on November 7th, 2024? Is that you?
Yes, ma'am.
All right, state.
Yes, Judge. Are proceeding with violation of condition number 1 on or about the 19th day of February 2025 in Bexar County, Texas. The defendant Roxanne Hutchison committed the offense of theft in violation of condition number 1.
How do you plead to that? True or not true?
True. The state will waive and abandon the remaining violations, Your Honor.
Any objections?
No objections, Your Honor.
All right. Did you understand by pleading true to violation of condition number 1, the court could find it true, grant the motion, find you guilty, I'm sorry, grant the motion and sentence you up to 10 years in the prison
Yes, ma'am.
and up to a $2,000 fine. Did you understand?
Yes, ma'am.
Knowing that, do you still wish to proceed with your violation of condition number 1 in your plea of true?
Yes, ma'am.
Court will find violation of condition number 1 true. Is there a proposed agreement?
There is, Your Honor, and it would involve the following case, which there's plea paperwork before the court for the same defendant.
Yes.
The state probation and believe defense's recommendation is to continue probationer on this probation in cause number 2024 CR 007949, but to amend conditions to now include state ISF, cognitive track, followed by ISP. And probation did make a note upon disposition of pending cases, the plea paperwork on cause number. Well, I see at 2025 AL 002862, there's a cause number I don't see right now, but those conditions would also reflect and run concurrent with this cause number.
All right, what has she done on probation?
Judge, the only thing that Ms. Hutchison has done on probation has been to provide her DNA sample as required.
She was recording, sorry.
She was reporting. She reported last May 7th of 2025.
She had been reporting previous to that as well.
Right, I'm saying her last reporting is on that date.
All right, so here's my question. Has she done her parenting classes? All right.
Judge,
Did she obtain employment?
Judge, if I may
Yes.
inform the court, she was doing the parenting classes through CPS. She has a CPS plan because she's trying to get her child back through CPS. So she's doing the CPS classes through CPS. She has a CPS plan. So she's going through CPS. So she has a CPS plan. So she's doing her parenting classes through CPS.
All right, so how long has the CPS case been open? Was it open before this case?
Yes, ma'am.
So I don't understand why the court has received the new number 1. She knows she has a CPS case, but she's picking up a new charge and she's not following through with the conditions of the court. I don't understand why I should follow the agreement to continue her.
Judge, I think she wants to
All right.
address the board.
You want to raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Roxanne Hutchison.
All right, why is the only tangent thing that I see from you is that you're picking up a new charge?
Hey. I know it doesn't reflect in the probation report or whatever, but since then I keep heroin. I've been sober for 9 months. I do admit that the issue wasn't me just getting sober. I got sober, but I was still doing the same things that an addict does. I was hanging around the same people. I didn't change my surroundings or my friends. So I continued to do the same things. I'm just asking for a chance to get treatment and not go to prison. I do have a 4-year-old son that I'm fighting for.
All right, so here's the thing. I don't understand why people don't think of their children before they pick up new offenses. I'm not following the agreement that you all have reached on this motion to revoke. I'm going to grant the motion revoke. Does anybody want to speak to time? She's looking at a maximum of 10 years.
Judge, we need to confer.
All right, sure.
Consider following the recommendation from probation and what the state originally wanted. Ms. Hutchinson is before the court. She verbalized that she needs help. She's asking the court for help. It's not often that a defendant is before the court and they are asking the court for some help. She is asking for help also with CPS so that she can get help from CPS. It's well known that addicts relapse. That's not uncommon. And that's what happened with her. And because that happened, she picked up other offenses. The state of Texas is willing to give her an opportunity. So I'm re-urging the court to give her that opportunity. She's not asking for you to release her. She's asking you to send her to inpatient treatment so that she can get some help. That's what she's asking. And so I'm re-urging the court to consider that.
All right. The court, as previously stated, is finding violation condition number 1 true, and the court is going to grant the motion to revoke. Does anyone wish to speak to time?
I believe that we will be going open on that. The state understands defendant is facing up to 10 on this MTR. The other case that will be before the court shortly had thoughts. Basically, the state is thinking, we pled true to number 1, you're facing 5 or facing 10, state would ask for around 5, Your Honor.
All right.
Judge, we're asking the court to sentence Ms. Hutchinson to 2 years in TDC.
All right. This is what the court is going to do. The court will sentence you to 4 years in the prison. The court will request the therapeutic community. The court will give you a credit for any time served. Did you review the trial court certification of defendant's rights to appeal with your attorney? Did you understand it?
Yes, please.
All right, so you have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you were on community supervision. Because it's a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do y'all want to reconsider the plea bargain agreement with the theft case?
Yes.
Yes, Your Honor.
All right.
I will get this done quickly, Your Honor.
All right, thank you. All right, the court is calling 2025 CR 0051553 State versus Roxanne Hutchinson. Can I have the parties announced for the record, please?
Duffy Pitlock for the state of Texas, Your Honor.
Richard Gossett for defense.
And are you Ms. Hutchinson?
Yes, ma'am.
Counsel, you received all discovery. Did you review it with your client?
Yes.
Court will find that the state is in compliance with discovery. Are there applications in this case?
No, Your Honor.
Ms. Hutchinson, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Your Honor, we are.
Ms. Hutchinson, did you review the court admonishments with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with theft of property less than $2,500 with 2 or more previous convictions as state jail felony?
Yes, ma'am.
Just one moment. Are you all waiving?
No, Your Honor, we are proceeding with the repeater to make this a 3rd-degree punishment range.
All right, thank you.
Yes, Judge.
If you all could write the repeater on here, please. All right, do you understand if the state approves of the repeater enhancement paragraph, then this will be a 3rd-degree felony. The range of punishment will be anywhere from 2 to 10 years in prison and up to a $10,000 fine?
Yes, ma'am.
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call on, the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
She has.
Do you believe she has a rational as well as a factual understanding of the charges against her?
Yes.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes.
Ms. Hutchinson, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, the state is proceeding on count 1. And is she going to agree that she's been previously convicted for purposes of enhancement?
Once we get to the stipulations,
If y'all would check the box. You further agree that you've been previously convicted of 1 or more felonies for purposes of enhancement. Your punishment is to be assessed at 4 years in the prison.
you're initialing this right now, Judge.
Thank you.
Our 2 initials will reflect that we.
All right, thank you. This will run concurrent with 2024 CR 07949. They were taking consideration 2025 CR 07240, 2025 PF 26020. There's to be restitution of $60 and to the Bear County Crime Lab and 2025 PF 26020. There's to be no contact with the complaining witness. Did you understand that to be your new plea?
Yes, ma'am.
Defense, is that the plea?
It is, Your Honor.
State, is that the plea?
Yes, it is, Judge.
And based upon the plea bargain agreement that you all reached, the court has drawn a line through certain things. If you all could initiate those, please.
Certainly, Judge.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it?
Yes, ma'am.
And did you sign it in both places?
Yes, ma'am.
Because this plea, did you understand by waiving that, you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, Your Honor.
Then this is charged. How do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence?
State offers State's Exhibit 1 and all attachments at this time, Your Honor.
No objections, Your Honor.
And I'm sorry, to the enhancement, how do you plead? True or not true?
True.
Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments, and the court will review the same. All right, after reviewing State's Exhibits 1 and attachments, the court will find that there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
And I'm sorry, and also the court will find the enhancement true based upon your plea of true and based upon State's Exhibits 1 and attachments. Anything you wish to say on behalf of your client?
Judge, we're asking the court to follow the recommendation of the ADA and run it concurrent with the motion to revoke.
All right, the court will sentence you to 4 years in the prison, give you credit for any time served. This is to run concurrently with 2024 CR 007949. State will take in consideration 2025 CR 007240, 2025 PF 26020, 2025 PF 26020. Restitution to Bear County Lab, and the cause number 2025 PF 26020. And the court will recommend the therapeutic community. Is there anything else with regards to sentencing?
May the state just confirm that it was two cases that were TIC?
Yes, it was 2025 CR 007240 and 2025 PF 2602. Sorry, 26020.
If the state may tender to the court.
Yes. Thank you, Judge. Did you review the trial court certification of defendants' rights to appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, good luck to you.
Yes.
And who is your other client, Bridget?
Adam.
Court is calling 2025 CR 002023, State versus Gregory Perneda. Can I have parties announced?
Duffy Pitlock for the state of Texas, Your Honor.
Nick Aguilar on behalf of the Honorable Gregory Perneda.
And are you Gregory Perneda?
Yes, ma'am.
All right. You are here. You were placed on probation. My understanding from both parties, you're asking the court to reconsider his sentence of probation.
Yes, Your Honor.
All right. Is there any objection to the court reconsidering the legal sentence that the court placed on Mr. Perneda?
No objection from the state, Your Honor.
All right. Is there an amended plea bargain agreement?
Yes, Your Honor.
All right. And Mr. Perneda, did you have a chance to review the amended plea bargain agreement with your attorney?
Yes, Your Honor.
Did you understand it?
Yes, Your Honor.
According to that plea bargain agreement, the state is waiving and abandoning the repeat enhancement paragraph. They're asking that your punishment be assessed at 2 years in the prison. There are no applications, and there's to be restitution of $60 to the Bexar County Crime Lab for testing. Did you understand that to be the new plea bargain agreement?
Yes, Your Honor.
Defense and state, are you all both understanding that as the plea bargain agreement?
Yes, and the state did fail to write amended on top of that.
Thank you.
We may at this time.
Yes, thank you.
And we concur with that plea bargain agreement.
And did you review the waiver of appeal paragraph with your attorney? Did you understand it?
Yes, Your Honor.
And did you sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
The previous stipulations that were entered into, are those being reoffered as well?
The state would, yes, Judge.
And we have no objection, Your Honor.
All right. So, Mr. Perneda, you were given probation, but it's the court's understanding that you were revoked. Yes. So therefore, that is the reason why you're asking me to be revoked from, not really revoked, but you're asking that this new plea bargain agreement be entered on your behalf?
Yes, ma'am.
All right. And so the previous probation, you were sentenced to 2 years, suspended for 3 years. So the 2 years is within the plea bargain agreement as far as your liability with time. Do you understand?
Yes.
All right. Are you ready to proceed with sentencing?
Yes, Your Honor.
All right. Then the court is going to sentence you to 2 years in the prison. There's to be restitution to the Bexar County Crime Lab of $60 for drug testing, and the court will give you credit for any time served. Is there anything else with regards to sentencing?
Nothing from the state, Your Honor.
Nothing from the defense, unless they can just tell us, somebody can tell us how many days he has back.
The clerk will be able to do that. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it?
Yes.
And did you sign it?
Yes.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you do not You're not allowed to possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, and I'll request the therapeutic community. Good luck to you, sir.
Thank you, Judge.
Thank you.
May we be excused?
Yes.
And I supplied the state with a USB, and I'm still missing 6 videos.
It's plus 6 videos missing. And do you know if they have this in their possession?
Yes, they do. I gave them a USB, but it wasn't large enough.
Okay.
And then I went ahead and I downloaded it. And so I narrowed it down to make it easier.
Mhm.
And now I'm just missing 6 videos. And I think the USB that they have should be large enough for them to upload it to that.
All right, Ms. Ferguson, can I have a 30-day reset for discovery? This will be the final reset for discovery. If there's an issue, then witnesses will need to be subpoenaed by the state.
I can do August 18th.
All right, August 18th.
I'm out that week.
All right.
I can do the 15th, the 14th, I'm sorry, or the week after that. Okay.
All right, we'll see you back on August 14th. All right, good luck to you.
Thank you.
You're welcome.
Just be back up there.
Jerry McGee, files, please. Is this for a motion to revoke?
It is just, he has some unindicted cases. I think the state wants to see if we can reach a reset so I can get a global health on all the pending cases that he had.
All right, and state, how long will that take?
Judge, if I can have 3 weeks, it is a total of 7 cases that I have to go through. That some of them I was looking through right now, and some of them do have evidence, but on the other ones, I'm gonna have to reach out and then I'll confer with Mr. Witter to resolve all cases.
All right, Ms. Ferguson, on McGee, I need a 3-week reset.
August 7th.
All right, we'll be back on August 7th, sir.
Sure.
All right, thank you. Xavier Doxy.
Have a seat, sir.
Yes, I do.
Oh, no, I need a break. I think, yeah, I need a break. Deputy Laura is looking at me with frowns. All right, court is calling 2019 CR 9540 State versus Xavier Dante Doxy. Could I have parties announced?
Megan Galloway for the state.
Catherine Valenzuela for the defense.
And are you Mr. Doxy?
Yes, ma'am.
Did you review the motion to enter adjudication of guilt with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Xavier Dante Doxy who was placed on deferred adjudication in 2019 CR 9540 for the offense of arson intention to damage habitation or place of worship on December 13th, 2019 for a period of 6 years? Is that you?
Yes, ma'am.
All right, state.
Violation of condition number 43 on or about the 14th day of May 2025 in Travis County, Texas. The defendant, Xavier Dante Doxy, did then and there fail to comply with the rules, regulations, or instructions of the Bexar County Community Supervision and Corrections Department Substance Abuse Felony Punishment Facility Continuum of Care Treatment Plan, in that the defendant was unsuccessfully discharged from a residential outpatient treatment program in violation of condition number 43.
The glass jar. All right. So to that violation, how do you plead? True or not true?
True.
And that is the only violation?
It is, Your Honor.
Okay. Did you understand by pleading true to violation of condition 43, the court could find it true, grant the motion, and sentence you up to life in prison and up to a $10,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition 43?
Yes.
Court will find violation of condition number 43 true. Is there a proposed agreement?
There is not, Your Honor. The state is asking for revocation and 8 years in the prison. This is the defendant's 5th MTR, and he's just failed to comply with his conditions of probation, and so that's why we're asking for what we are asking.
Why isn't he complying with conditions?
Here, for the court's clarification, that one of the recommendations for probation on that form was that he be placed in state ISF with the cognitive tracks. Yes, it's the fifth NPR. He has successfully completed all of the programs that have been inpatient. He's gone to ISF, he's gone to SAC.
So why didn't he successfully complete this?
I believe, Your Honor, and this is just preliminary, what I believe is that one, Mr. Doxey has not been evaluated for the mental health component when he was younger. He did have issues with ADHD. He did have issues in completing tasks. When we talked about it immediately, he said he knows he needs help. He knows that aftercare is the issue for him. He's very good at completing what we ask him to in a program, but it's the aftercare that's the problem. And so it's making better decisions, and that's why we're asking for the cognitive track.
All right, so here's the issue. I think everybody knew that there were mental health issues if you're trying to burn down a church. So that's a given. Everybody knew that there were some mental health issues. So that is why I had him evaluated for McBioff at the very beginning. This is his fifth MTR. There is nothing else the court feels that the court can do for him. It's his fifth MTR. And I understand probation's recommendation, but probation's recommendation for some people who've been missing for 4 years is continue. It's like, where's this person been?
Right.
So their recommendation, I do take it with a grain of salt, but I do internalize what they're recommending. But it's his fifth motion to revoke. There's nothing else. I don't think he's appropriate for probation.
And we understand that would be difficult. And we talked about possibly working with the state and coming up with a number that would justify. I mean, he has roughly done 3 years in the course of treatment in inpatient and in jail, waiting to go to inpatient. And inpatient is not like, a walk in the park or a vacation. And I think he would like to address why he would like to stay on probation and what he feels like he would get out of probation and what he could do if you would wish to hear that.
I mean, if he wants to present a testimony to the court, I'm always open-minded. You want to raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Xavier Dante Dodson.
All right. Do you just want to give a statement or do you want to do question and answer, counsel?
I think he can give a statement where he discusses.
All right.
Basically, Your Honor, I feel like the leniency that's been shown from the court is very much appreciated. And I understand my flaws. I'm capable of understanding where I was wrong and where from another perspective, it doesn't look that good. But I know where I need help. I know where my strengths lie, as well as my flaws. And I do believe with the cognitive track and the opportunity to set myself on a better path would be implemented. And I think that more structure is the key here for me, if I do say so myself.
All right, so let me just tell you this. I'm internalizing what you're saying. Here's the issue. I know that sometimes people do great when they have somebody in their life to tell them everything to do every day from the time you wake up and from the time you go to bed, right?
True.
But I don't have the manpower or the hours to do that. I don't have anybody from this court who can call you for the rest of your life to make you do certain things. So you had the first motion to revoke. You will continue. Second motion to revoke, you were continued. Third motion to revoke, you were continued. Fourth motion to revoke, you were continued. And now we are here on the fifth motion. There's just nothing left for the court to do. And each time that a motion to revoke was filed, each time whatever issue you were having, conditions were set to help you address that. Your attorney is saying that you need ISF. That would help you, the ISF cognitive. But you've already been given the MRT because the last attorney you were here with said the same thing, and the court addressed that with the programs and tools that I had to address that. And the MRT was to address that. So I just don't think you're a good candidate for probation. I wish there were more programs available where there could be a case manager automatically, somebody to check in on you at least once every 2 weeks or once a month, but I just don't have the manpower for that. So I don't believe that you're appropriate. But I will tell you this, I do appreciate your giving me some insight into you.
Yes, ma'am.
And that you understand where you've gone wrong. So his states you were requesting 5 years?
It's requesting 8 years.
All right, so you're requesting 8 years. So probation, there any new cases or no?
Judge, I do not see any cases.
All right, the court is going to take into consideration everything that your client has with the mental health issues, the fact that we really don't have the programs or tools equipped to handle his issues. So I'm taking all of that in consideration when I give him his sentence. So I'm going to sentence him to 6 years in the prison, give him credit for any time served. There's to be no contact with Danielle Yorks, Yorks. And I request the therapeutic community. All right, did you review? Just one moment, I'm so sorry. Let me find out. The court is going to find you guilty and revoke. Did you review the trial court certification of defendant's rights to appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
All right, you do have a limited right to appeal, and that right to appeal is as it relates to the allegations in the motion, not the fact that you are on deferred adjudication. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, here's the thing. When you're released from custody, if you can't find a place to help you with your mental health issue, if I'm here, you can come back and address that with me.
Yes,
But I would stress to you that when you're released, the first thing you should do is go to Center for Healthcare Services, okay?
yes, ma'am.
All right, good luck to you.
Yes, ma'am.
Thank you.
And just for clarification, the credit would also include inpatient programs that he could successfully.
Yes, I'll give him credit for any successful inpatient treatment.
Thank you, Your Honor. We appreciate your consideration.
Thank you.
We're just requesting a reset. It's the first setting.
Let me find him on the docket. Matthew Martinez. All right. State, where are you on discovery?
To my knowledge, everything's been disclosed, Your Honor.
Were you able to tender an offer?
I have, yes, Your Honor.
Sir, how old are you?
36.
All right, Ms. Ferguson, I need a 3-week reset for a plea deadline date, please. All right, once you sign, just have a seat. Once you sign the reset form, you'll be excused.
Thank you.
You're welcome. Who's here? Ruth Payne.
President.
Hello.
Morning, Judge. How are you?
Oh, it's been a
Good
day.
afternoon.
Yeah, good afternoon.
Good evening.
All right, the court is calling 2025 CR 004178 State versus Ruth Gonzalez Payne. Could I have parties announced?
Duffy Hitlock for the state of Texas, Your Honor.
Chris Arce for the defense, Your Honor.
And are you Ms. Payne?
Yes, I am.
All right. Counsel, have you received all discovery? Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Ms. Payne, did you review the application for community supervision with your attorney?
Yes.
All right, are you applying for deferred adjudication or community supervision?
Deferred adjudication.
Did you review, because both are signed, that's okay. Did you review the document entitled Application for Deferred Adjudication with your attorney? Did you understand it and sign it?
Yes, Your Honor.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Ms. Payne, did you review the admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Did you understand you're charged with possession of a controlled substance penalty group 2 less than 1 gram as a state jail felony? Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Yes, Your Honor.
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and sentences you to more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state will call on the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 2 years in the state jail facility and up to a $10,000 fine?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
She has, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
She does, Your Honor.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Ms. Payne, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No.
Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes, Your Honor, I have.
Are you a U.S. citizen?
Yes, I am.
Court will find that defendant has knowingly and voluntarily waived her rights to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes.
According to the plea, there's a $1,000 fine. State recommends deferred adjudication. Did you understand that to be the plea?
Yes, Your Honor.
Defense?
Yes, Your Honor. I did want to ask for the court's consideration on the $1,000 fine.
Okay. All right, state.
That is the agreement.
All right, did you review the waiver of appeal paragraph? Did you understand it? Sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, are there been any such motions?
No, Your Honor.
Outside the agreement, the state is requesting that your community supervision be for a term of 2 years. There be a TAP evaluation, 120 hours of community service restitution, and no driving without a valid license. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, Your Honor.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
State offers States Exhibit 1 and all attachments at this time, Your Honor.
All right, did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in, the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence States Exhibits 1 and attachments. The court has reviewed the same. The court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you apply for deferred adjudication. Are you proceeding with sentencing?
Yes, Your Honor. Also, may I have an opportunity to
Yes.
speak on Ms. Payne's behalf? She's 58 years old, Your Honor. She's fully employed. She takes care of her elderly husband, who is 75 years old, who is a Vietnam veteran, who is legally blind from a stroke that he suffered. I wanted to discuss the possibility of early termination of probation as we intend on getting all the requirements done within the next 6 to 12 months. Further, Your Honor, the $1,000 fine, as she is a sole provider, she's fully employed, but they're basically just relying on her paycheck. We're asking for that to be waived as well, Judge.
All right. So what is your employment?
I work for Brett Lawyer Insurance.
All right. And do you have any minors in your home?
No, ma'am, I don't.
So why are you doing this offense?
I don't know, ma'am, I can't.
I mean, well, what caused you to do it? And let me just tell you, the reason why I ask some of these questions is because you need to figure out why you are doing what you do so that you won't repeat it and that you can get clean and sober.
I have not smoked. I am clean at the moment.
Okay.
And I will be for the future. I will not smoke again.
May I speak on her behalf, Your Honor?
So what caused you to do this? What was going on?
I have always smoked.
What, this?
No, not that.
So why did you smoke this?
Actually, that did not belong to me. I had it in my purse and I forgot that it was there. I smoke marijuana. I do not vape though.
Okay. Does she have any prior history?
We can check her now.
Nothing other than a DWLI, Judge.
And how old are you?
I'm 58.
Okay. Do you have any criminal history other than this?
The state can confirm this.
Okay.
This is true.
Let's go off the record for a moment.
You got. Around the corner, around the corner. Second. Go downstairs. Who's here for this? Won't even start.
And counsel, this is just something that I wonder, because if she doesn't have any criminal history, maybe this is not for her, maybe PTD.
I agree.
Okay. Counsel, if you all want more time to discuss it, we can come back at 2. Well, you can see.
It'll just be a couple moments.
Okay, no problem.
Yeah, is this on the record or?
Oh, no, we're not. Here's the thing. The court is not, any objection to the court not sentencing the defendant today?
No objection from the state, Your Honor.
And you're waiving PSI and TAP?
Yes, sir.
All right. So as previously stated, the court is going to find there's sufficient evidence to find you guilty. The court will defer finding of guilt. When do you think your client will have items done to present to the state?
I would say 3 months, 4 months max. We've already been on it. It's just a matter of dealing with these smaller counties that these tickets are on.
I'm going to tell
You
you.
get paperwork from them within the next 30 to 60 days.
All right. So I'm going to give you a 2-month reset. After that, she's going to be sentenced.
Understood.
All right, Ms. Ferguson, if I could have a 2-month reset for sentencing. Right, September 15th, once you sign the reset form, you are excused.
Thank you, Your Honor.
You're
May we
welcome.
be excused.
You're welcome.
Thank you, Judge.
You're welcome.